Hello, welcome to today's exciting episode of the Law Show. My name is Dele Igbinedion, and on this episode of the Law Show, we'll be talking about how to sue a lecturer who asks for sex for grades. Sex for grades. How to sue a lecturer who asks for sex for grades. We'll be looking at, who can you sue? How can you sue? How much can you sue for? What law allows you to sue? And if this thing happened when you were a student 10, 15, 20 years ago, can you still sue? We'll be talking about it when we come back. So please don't go away. 24 hours, 7 days a week.
For more exciting, educative, and entertaining programs such as Law and You, Talk Politics, Entertainment Gist, Relationship Talk, Top 5 Gems, and other programs, keep watching Pinnacle TV. You can watch, like, and subscribe to our YouTube channel at Pinnacle TV Online. You can also visit our website at www.pinnacletv.com. Follow us on Facebook at Pinnacle TV Online or call us on 081 546 99989. Pinnacle TV, top quality broadcast.
Okay, so it's heartbreaking, but it is common knowledge now that lecturers in government-owned institutions, either federal or state, institutions, ask for sex in order to give grades to female students. So you have to sex this lecturer in order to pass. If you don't sex, you don't pass. The most public one, I believe, is the one of Monica Osage, from whom a lecturer in one university, I think it was University of Ibadan or some place in the western part of Nigeria, in Africa, requested that she must have sex with him 5 times. Not just once, not twice, not 3 times, not 4 times, 5 complete times in order for her to pass her exams. So she was smart enough to record it. And, as they say, the rest is history. The lecturer right now is in prison. And, so that's served as a causa celebre for this sort of thing. So today we'll be looking at how do you sue a lecturer in that situation. The first thing I want to talk about is, do you have rights at all? Does the student have any right whatsoever to sue this lecturer, either present lecturer or past lecturer? And don't forget that some of these things, if you are watching, this could have happened 3 years ago. You've graduated maybe 5 years ago, maybe 10 years ago, maybe 15 years, maybe even 20 years ago. However, you're still suffering from the trauma and the psychological pain of the event, of the incident, how you were coerced by this randy lecturer to force you to sleep with him in order to pass. Not that you couldn't have passed otherwise, because there's this talk out there that many girls, many women who have passed, who have graduated, may have graduated using sex without having read anything. I don't think that is the issue. The issue is that the lecturers will refuse to pass you, even if you merit to pass, until you sleep with them. So, what are your rights in this regard? What are the rights in this regard? The 2 things I want you to realize here, when talking about, what are your rights. The first is that when a man, in this context, a lecturer, sleeps with a girl, by way of intimidation, uses intimidation as a tool to achieve that, intercourse. Intimidation: if you don't do this, you're not going to pass. If you don't do this, I'm going to fail you. Now, the consent that is given by the female student in law is deemed to be no consent at all, because the law presumes that consent must be freely, voluntarily given. So when consent is obtained by force or fraud or intimidation of any kind in order to sleep with a woman or a girl, that is rape. Okay? That is rape. So the first thing is, it is actually a crime, punishable with imprisonment for life. That's the maximum punishment, imprisonment for life. So you have to understand this. That is the first law that allows a female student who's been raped virtually. I mean, I describe it as rape. Once sex is obtained by consent, which is not actually consent, then it's rape, no matter how the lecturer may want to characterize it. So that is against the criminal law of Nigeria. And the punishment is life imprisonment. So you have to be aware, if you are a lecturer and you are watching this, be aware that you are playing with life imprisonment. That is on the one hand. Now, on the other hand is the civil aspect of it. When a girl is put through that situation, her fundamental rights are breached. Fundamental right. Now, I don't want to go into too much intricacies of the law in this episode. We can do that on other episodes on fundamental rights, and you can watch that. But just so you know, every person has a right to freedom from inhuman or degrading treatment. Any treatment that degrades the psychology, the self-worth, the beingness of that person, of that female, you subject her to a regrettable, decision, a regrettable position where she's crying, and for years on end, she remembers the incident and she's full of sorrow. You have just breached her right to freedom from inhuman or degrading treatment. Now, I say this because, a lot of people could say, oh, it's just an act of sexual intercourse. But actually it's not. One of the girls who was interviewed on one occasion said she has attempted suicide 4 times. And all traceable to the fact that a lecturer in a university compelled her to sleep with him when she didn't want to do it. And not just once, over a period of time. Now that affected her psychology. And she's tried to kill herself 4 times. She's become suicidal. And okay, that may be an extreme. There may be other people who are living with it and who, anytime they remember that lecturer or remember the incident, they feel bad. Or perhaps the lecturer, still drives around. Maybe they live in the same neighborhood, and when the lecturer drives by, he looks at her like, "Oh God, I've had that girl, I've had you," and the girl feels bad or feels sorry. You've degraded her right to freedom from inhuman or degrading treatment. You've actually degraded her humanity, which is constitutionally protected. Okay, so those are the 2 laws that you probably want to look at. So the first one is a criminal law, the offense of rape, for which you can go in for life. The second one is, a breach of fundamental rights. Okay, and then below the breach of fundamental rights is the thought of battery, because if you have sexual intercourse with a woman without her consent, or if the consent is obtained by fraud or force or intimidation of any kind, it means that the act you were doing to her was without her consent, in fact. And that constitutes the thought of battery. Okay? So simply put, it's battery. So you are battering her, or breaching her fundamental rights, or you are on the top end of the scale, you are committing an offense of rape for which you can go in for life. Okay? So it's serious business. So those are the laws that permit that. Now, I want to talk about who can be sued, in this regard. Who can be sued? Obviously, the first person who can be sued is the lecturer. That's obvious. The lecturer. You've got to know the lecturer. Even if it happened 10 years ago, 15 years ago, 20 years ago, you need to find out where he is. Whoever he is now, you can sue him. And for good measure, if he is dead, you can sue his estate. You can sue his dependents. Okay? So we're going to talk a little bit about that. So the lecturer is number 1 to be sued. Number 2, his supervisor. Because no lecturer actually works in an institution without some level of control or superintendentship by somebody else. So there may be a head of department, there may be a dean of a faculty at that time, who ought to have put in place policies to ensure that that kind of thing does not occur, within that study environment. Because people go to school to acquire education. They go to school to acquire a philosophy of life. They go to school to acquire a mindset, a way of thinking. And, there should be policies put in place by every institution. Otherwise, the lecturer will be liable. The person in charge, either the head of department or the dean of the faculty, can also be suable. Suable, yes. And then the big one, with a big pocket, is the institution itself. The university or college of education or polytechnic or whatever you call it itself. So these are three people that can be liable. Now, if the government also did not put measures in place, the government also could be joined as a defendant. Okay? So you are looking at 4 categories of people. The lecturer, his supervising head, the institution, and the government that owns that institution. It is not exculpatory for the government to say, oh, blah, 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 we didn't know about that, it was not reported to us. You ought to put in place measures. It's like saying a fire burns down and kills somebody, and when you say, oh, the fire wasn't reported to us, or we weren't told that that place could burn down, you ought to take proactive measures. These are expected of you in law. The law of thought works on the principle we lawyers call the neighborhood principle. Just love your neighbor as you want to be loved. In other words, put measures in place to keep your neighbor safe as you would want to be kept safe. So please, if you are watching, you need to make notes about these 4 categories of people who can be sued: the lecturer, the supervising head, the dean or the head of department, the institution, and then the government. So it's no excuse for the head of department to say, well, I didn't know about it, blah, blah, blah. You are just talking. You ought to put measures in place, because when the suit is filed against you, the onus will be on you to now produce some kind of policy document, some kind of training manual, some kind of conditions of employment where you have made this point that a lecturer ought not to engage in that conduct. And so far from what we observe in most institutions, they don't have that as a condition of employment. They don't even have it, it's like, lecturer, go and do, what you have to do. And I dare say that in most cases, most institutions, have a principle of camaraderie, esprit de corps. Oh, this lecturer does it, the other lecturer does it, so all of us are doing it. So, what's the big deal? I particularly remember the heartbreaking case of a lady who reported to me years ago. This lady was doing a PhD program in an institution. I won't mention the name now. She was doing a PhD program in an institution, and her supervisor, I think that's what it's called, supervisor, wanted to sleep with her. So she refused. 5 years she was on her PhD program without making any progress because she refused his sexual advances. On the 5th year, she went to the head of department and reported. Said, look, this man is troubling me. And for 5 years, I haven't made progress because everything I write is always against me. He doesn't supervise me. And then the head of department asked her, for 5 years you have been here? He said, yes. Oh, why didn't you just let him do it? It wouldn't have taken 30 minutes. Instead of spending 5 years, you could have done it in 30 minutes and then you would have been on your way. See? So, heads of departments are complicit in this sort of thing. The university institution itself complicit, and the government, the commissioner for education, the governor, all complicit in this thing. So everybody deserves to get sued. All right. Now we've looked at the law which permits you to do it. Now there's something that I want to talk about here, and this is important, and I will continue this when I come back We'll just go a short break and then we'll be right back. Don't forget to subscribe to our YouTube channel. If you are enjoying this, let me know your comments. If you are not enjoying it, if you hate what I'm talking about, also let me know your comments in the comment section. But if you like it, subscribe and click the notification bell so that you can always get regular updates on our videos. Do not go away. 24 hours, 7 days a week. You can find your favorite program, Law and You, only on Pinnacle TV. Welcome back. Now, we're talking about how to sue a lecturer who demands sex for grades. Now, I'm aware, I'm very aware that it may be incongruous, it may be impractical, it may be not very useful for a female student to institute an action while she is a student in the school against her lecturer. So most girls, most females may want to keep quiet about it, graduate, and thereafter, once they are out of the environment, they can institute the action. So now this brings into fore a challenge. How long do you have to institute this action? Okay? How long do you have? So this brings the issue of limitation. How long do you have to file such an action? Now, if it's a public institution, and this is prevalent, I believe this sex for grades is prevalent in public institutions, and then it means that the lecturer is a public officer. There is the Public Officers Protection Act, which all public officers always try to use as a defense to say you must institute the action within 3 months. Within 3 months, you must institute the action. That is by the Public Officers Protection Act. Okay? However, the Supreme Court of Nigeria has come out to say, if you are a public servant and what you did was not in the cost of your employment, was not in the cost of your legitimate, duty or business, you can't rely on the Public Officers Protection Act. It's not, the Public Officers Protection Act is to protect genuine civil servants, genuine government workers who are doing their job, but, something just happens. Not someone who goes out of his way on a frolic of his own, to just assault people or batter people or rape students, and then later you say, oh, I'm a public officer, I should have sued me within 3 months. So that's the first thing you probably want to bear in mind. And if you have a case, get a lawyer, talk to a lawyer about this. The second thing is that generally in law, we have what we call a limitation period, which is 6 years for tort. Because if you are suing a lecturer for battery, the tort of battery, assault and battery, in the context that the sexual intercourse was obtained by fraud or by intimidation. So, in other words, he assaulted you or battered you. There's also the thought of intentional infliction of emotional harm. Because from the battery, from the incident, from the sexual incident, you could have years upon years or months upon months of emotional torture and thinking and distress and all that. So that is also actionable. You can sue for that. Then, but if you are to sue for this, then you need to do it within 6 years, because the limitation period for tort is 6 years. So once you leave the school, 6 years from the time that you leave the school, you can actually institute this action safely for tort. All right, so that's that. Now, if it's more than 6 years, because you could actually sue, for, 10 years, 20 years, 100 years, no student has been there for 100 years, but, irrespective of the length of time, you could actually fish out that lecturer, fish out the institution, and sue them. But you cannot sue pursuant to the law of tort, yes, T-O-R-T, if it's more than 6 years. You have to go, into the constitution to sue under what in Nigeria we call the Fundamental Rights Enforcement Procedure Rules. FREP rules, Fundamental Rights Enforcement Procedure Rules, the FREP rules. Now, the provision in the FREP rules is that limitation laws don't apply to breaches of fundamental rights. So, and this is a beautiful thing. limitation laws, no limitation law, no limitation statute whatsoever applies when the complaint relates to a breach of a fundamental right. And so if you are suing for breach of your right to freedom from inhuman or degrading treatment, and then you can add the thought of battery, you can add intentional infliction of emotional harm, as ancillary reliefs, you can situate that suit within the context of the fundamental rights enforcement procedure rules. Okay? So you can sue even if it's 10 years, it's 5 years. So as you are watching this, if it has happened to you, and it's happened 3 years ago, 5 years ago, 10 years ago, even 20 years ago, 10 years ago, and the lecturer is doing very well, you can still sue him for every penny that he has. Okay? So no limitation of action if you sue under the fundamental rights rules. I hope that's very clear. Great. Okay, now I come to a big issue. And the big issue is, it's good to sue, but when you get to court, you need to prove your case, isn't it? That's elementary. You have to produce the evidence, because the lecturer is going to come, fighting with, jabbing with two fists, saying, I don't know this girl, I'd never met her, whatever we did was consensual, I never forced her, she was just my girlfriend, blah, blah, blah. So, the lecturer is going to come out swinging with all of this. So, you need to prepare, you need to prepare for this fight, because it's going to be a fight. Now, what I mean by that is you need to have your evidence handy, So if your lecturer is harassing you right now as you are watching, there are things you can do now which you can use in future after you have graduated against that lecturer. Number one, you keep your records of text messages. Okay? Records of phone calls. You record your phone calls. When he calls you, he's harassing you, calling you at 12 p.m., calling you at 2 a.m., calling you at odd hours. You just, if you have an Android phone or any phone that records, you just press the record button and keep record of all these conversations, that unwanted conversations, unwelcome conversations, unsolicited conversations. And then you record at the point when you tell him, look, I really don't want to do this, So you record all of that. So keep records of your text messages, keep records of your phone calls, keep records of lewd or sexually explicit messages. If he sends you those messages, oh, you are looking fine today. Things that have no relationship with your course of study. If you are studying medicine or geography or history, and he's sending you text, oh, you look very beautiful today. You look like Mount Kilimanjaro. All those sort of things. You want to keep records of them. You keep records of places that he visits, hotels that he takes you to. Generally, you can keep a diary or a journal. Now, this can come in handy, because these lecturers, they are evil people, trust me. They would always deny. They would say, oh, it never happened. Oh, no. It never happened like that. So you need your evidence. Okay? Take pictures. Take videos as much as you can. You need to keep records. Now, important points you need to note here. Telecommunications companies in Nigeria, they keep records of text and phone messages, phone calls, for a year. They don't keep it beyond a year. In the UK, there's a statutory obligation to keep it for 6 years, to keep records for 6 years. But in Nigeria, they keep it for just 1 year, and then they tell you, it's all wiped off. So you've got to keep this in mind, and keep your own record. You can actually download text messages and print them out and keep them, in a printed form, showing his phone number. You can screenshot messages, text messages, and all of that, and keep records. Now, I'm not saying make every lecturer begin to turn every lecturer into a predator. Every message of hello, how are you that the lecturer sends, you record it. But you know what I mean. You get the gist. The ones that are unwanted are the ones we're talking about. I mean, someone can compliment you and say, oh, you look nice today. It doesn't mean you quickly go and print out that one and keep it. But the ones that you really don't want, the ones that are threatening, the ones that are intimidating, the ones that are tending towards, compelling you, forcing you against your will, against your better judgment to do this. In order to get that, so you need to keep record, because when the battle starts, it's going to say, I didn't do it. I didn't do it. Okay? So you got to be able to make sure, you get him to do it. All right. Now, how much can you claim? I'm sure that's something that I'm always interested in. I like to know how much, people can claim. And I'm sure you also want to know how much you can claim. There are two things that the law allows you to claim in this context. Two things. One is you can kill the lecturer. The law doesn't say you're going to kill the lecturer. If you sue him in a civil court, you can claim financial compensation from him, or the school, or the institution, or the government. If you join all of them, or the head of department, you can sue them jointly and severally, and sue them for millions of naira. And for me, a lawsuit, the compensation claim or relief in a lawsuit is about adding some extra zeros at the end. Okay, so just play with the zeros. You can just start with 1 and just add 3 zeros plus another 3 plus another 3. That averages out to $1 billion. So sue it for $1 billion or 100 million or 500 million or something that you get a good judge that really wants to set an example, can award probably, within the context of your claim, because it can't give you more than you have claimed. So the higher you claim, the more latitude you give the judge to be able, to hit the lecturer hard. Okay? So if the lecturer comes out with a judgment of probably 300-400 million naira for harassing a girl, don't you think other lecturers will quickly, take an example from that? I think so. Can a judge award 100 to 300 million naira for this? Of course. Okay. And mind you, I have to say this, so if you are watching this and you are a male lecturer, remember that most of our judges now are female judges. Most are female judges. They don't belong to your confraternity. They don't belong to your group. They don't belong to your social club. Most are female judges who close from court and go home. They don't go and drink in bars. So there is no way for you to interact. When you appear before them, you will have yourself to blame. Okay. So that's the first thing you can claim. Compensation, millions of naira, I recommend. Second one is you can ask for an apology. And it could be a public apology. The court can actually order the lecturer to deliver a public apology. And it could be anything from, he should stand in front of his class and deliver an apology to you. Or he should write an apology and publish it in a newspaper of national circulation. Or better still, he should publish it on Pinnacle TV for everybody to see. Okay? All right. So those are two things you need to bear in mind you can claim. You can claim millions upon millions of naira. You can also claim an apology, okay, from the Randy lecturer. All right, now, I want to address this point because I know it could be difficult for girls who have gone through this experience to be able to afford lawyers, million naira lawyers to take up cases for them. So I want to appeal to you, if you are watching and you are a lawyer, take some of these cases on pro bono. You know what I mean by pro bono publico? Take it on the basis of a no-win, no-fee. In other words, you render a social service to these girls, to these, helpless women who have gone through this experience. Okay? So, it's up to you, lawyers. And that's how it's going to be today on the Law and You show on how to sue lecturers who ask for sex for grades. And don't forget to subscribe to our YouTube channel. Once you open our YouTube page, you see the red button that says subscribe. It's written out there in red. You just click on it. It doesn't cost you anything. It doesn't cost you anything. In fact, you benefit because one, YouTube will recognize you as a regular watcher. Then two, they can always send you notifications of our videos. Anytime we upload a video, let you see it so that you can decide whether you want to watch it or whether you don't want to watch it. But Unless you subscribe, then they cannot regularly send you all of these videos. And we want you to subscribe. And it's also beneficial for us because we need to hit a 1,000 number, 1,000 subscribers for YouTube, to actually take us seriously. So I encourage you to subscribe. Please subscribe. 24 hours, 7 days a week.
For more exciting, educative, and entertaining programs such as Law and You, Talk Politics, Entertainment Gist, Relationship Talk, Top 5 Gems, and other programs, keep watching Pinnacle TV. You can watch live and subscribe to our YouTube channel at Pinnacle TV Online. You can also visit our website at www.pinnacletv.com. Follow us on Facebook at Pinnacle TV Online or call us on 081 546 99